this is case number 20163-588. This is Shania Sullivan versus Allstate Fire and Casualty. Matters before the court set on for a pretrial conference. Your appearance for the plaintiff in this matter, please.
Morning, Your Honor. James Eccleberry appearing on behalf of Plaintiff Shania Sullivan, P78222.
Thank you, Mr. Eccleberry. Good morning to you, sir. Your appearance for the defendant in this matter, counsel.
Good morning, Your Honor. Christian Vervac on behalf of defendant, P number 83054.
Thank you, sir. And good morning to you as well. I see that you've completed, looks like, discovery in this matter. So somebody update me on what the status of things are at this point, please.
Your Honor, plaintiff made a settlement demand back in mid-November. We received a response to that demand. Counsel and I had a conversation yesterday in anticipation of this conference. We are still quite a ways away of meeting point in terms of settlement, but we both are, I guess, reservedly optimistic that we'll be able to make progress and eventually get this case resolved. We have discussed going to a private facilitator in an effort to aid the parties in bringing us to a resolution. We've kicked about some names that we might agree to and who might be available sooner rather than later. Obviously, we're aware that the court has been gracious with its time on this file. We're not looking to abuse that.
Got it. That makes sense to you, counsel?
Yes, it does. Yeah, this case is a little bit more complicated. It's an underlying, patient suit. So there's several medical providers that have claims, and there's a wage loss component. So I definitely think that a private facilitation would speed the process up and likely turn out a resolution.
Right. Everything that I'm hearing, it certainly suggests to myself that approach is a prudent approach. Both counsels seem to be quite engaged in the prospect that the case could be resolved, but the engagement of some objective third party may help to force that in. So I'll set it in that particular protocol. How much time you think you need to get that all set up? And I know that facilitators and everybody's busy now. Things haven't been ramped back up. So I'm wondering if I set a 60-day calendar on an issue in order for facilitation, if that will get you towards that conclusion.
So I think we could probably squeeze in with one of these facilitators within 60 days. I can't be certain, but I think it's possible.
I would agree.
All right. So what I'm going to do is I'll set a calendar on the matter to bring you back for an adjourned final pretrial conference, and that will be some 60 days hence. The specific date is going to be
February the 16th.
2/16/22, and we'll set that on at 9:30 a.m. 2/16/22, 9:30 a.m. You will get an order from me with that date, and also an order that the matter be facilitated. I know that is something that is voluntary and pretty much consensual between the parties, just so that we have it documented. And do your best. And if the wisdom of the facilitator is insufficient, then perhaps the court can take some time and see if with degree of wisdom over the years, and maybe I can pay in some things. So hopefully you get it worked out. If not, we'll take some time to try and kind of take a look at it on the 16th. All right, I wish you well, gentlemen. Good day to you, and the best of the holiday season to you as well.
Thank you, Your Honor. You too.
Thank you, Your Honor. You as well.
All right, this is case number 21-152086. This is Diversified Member Credit Union versus Anthony Wiley, the third. The matter is before the court set on for a hearing after submission of an answer to this matter. Do I have counsel for Diversified? All right, we'll come back to that matter momentarily. Let me see if I have the parties on Michigan First Rehab, case number 21. 21-161-394. This is Michigan First Rehab versus Nationwide Mutual Insurance Company. The matter is before the court, set up for a pretrial conference. Counsel for the plaintiff, your appearance at this time, please.
Good morning, Your Honor. Sandra Toma appearing on behalf of Plaintiff Michigan First Rehab, P number 84575.
All right, thank you, Ms. Tolman. Good morning to you, ma'am. Let's see if we have counsel for defendant on this matter. Nationwide.
Based on the caption, based on my caption, I don't see anybody here.
Right. So when's the last time you spoke with anybody with Nationwide?
We sent over our answers to their discovery month and a half ago. They did not respond with any type of suggestion that they received it, but it went through per our email server. And I did make a phone call to discuss before this pretrial, but I was not spoken to, or the phone call wasn't returned, I should say.
All right, and the record would reflect that the notice that was sent out has the correct date of the 16th of December and the time, and it also has the meeting ID number. You've not received any call or anything today indicating persons are in other places or anything along those lines, have you?
I'm sorry, that last part, Your Honor.
You haven't received any communication that might suggest that the defendant is in some other place or not able to make it. You haven't received anything along those lines. Is that correct?
That is correct, Your Honor. No, I have not received anything like that.
All right, Madam Counsel, your pleasure at this time.
Quite honestly, Your Honor, I will leave it up to your discretion for what you would like to do with it. I don't mind an adjournment, but I do need some type of communication to happen.
All right. Yeah, I don't like the lack of communication stuff. All right, I'll go ahead and set it over for a brief time. I'd like to kind of get on this and see what's going on. So we're going to set it out about 30 days, and we'll get back at that time. The other side will be notified once again regarding this matter. I will be inclined to enter their default if they do not appear at the next hearing. So that next
Okay.
date, 3 days hence, is going to be on the
13th.
January 13, 2021. And that's going to be at 9:30 a.m.
Okay, that works out perfectly.
All right, thank you, Council. And a notice will be generated by mail as well. All right.
Thank you, Your
Well,
Honor.
that's-
Good holiday. Thank you.
And this is case number, Mr. Marnico, I'm getting ready to call your matter in just a few moments. I see it's set for 9:45. Have you spoken with Mr. Fortner today or recently?
We spoke yesterday through email, or I think it was email. And then I tried to call him this morning to follow up and got voicemail. I can try again though in a second here.
All right, then I'll call it in a bit.
Thanks.
right, this is a recall on the suffix 2086 diversified members credit union versus Anthony Wiley III. Appearance for the plaintiff in this matter.
Good morning, Your Honor. Weston Young, on behalf of Diversified, P number 80307.
Good morning to you, counsel. And it looks like I see Mr. Wiley on the Zoom. Say something if you're here, sir.
How you doing, sir?
All right, good morning to you, sir. I'm well this morning. All right, so I have this set up for a hearing on today's date because I did receive an answer to the complaint in this matter. And typically, this hearing is to set up some type of schedule so that parties can advance the cause as before the court. And sometimes the parties are able to get it worked out even at this stage of the proceeding. So, counsel, Mr. Neal, have you had opportunity to speak with Mr. Wiley prior to now?
I have, Your Honor, and to save the court a little bit of time, we discussed the matter thoroughly and have come to a resolution. Mr. Wiley is not contesting that he owes the balance. It's just his ability to pay. So we've agreed to a consent judgment with a non-collection provision that will provide that he will provide documentation beginning of February for a financial review, and then we'll discuss payments at that time.
That makes sense to you, Mr. Wiley?
Yes, sir.
All right. All right. It sounds like a reasonable way to go forward, and I will sign the order upon presenting to the court. And so it is your agreement to enter into a consent judgment for the amount that the two of you spoke about in the breakout. Is that correct, sir?
Yes, sir.
And you have no objection to the court signing such an order, particularly where it has a provision that there will be no collection efforts, and that the party will review the matter for payment resolution in February 2022. Is that correct, sir?
Yes, sir.
All right. The court will find that there is a consent agreement in this matter. Counsel, you may submit the order to the court with the terms as set forth, given that there is an agreement on the record, and I will sign it so that we can get this forward. Do you have the email address where you can send it to the court, sir?
No, if the court could provide that, I'll be sure to get that out today, Your Honor.
All right, that's Latifah, LATIFAH .Hunter at 36districtcourt.org. 36th at 36districtcourt.org.
Got it. Thank you, Your Honor.
All right, and then a copy will be sent to you, Mr. Wiley, as soon as it's
Okay.
entered. And wish you well, sir. All the best to you. Thank you, Mr. Mayor.
Thank you, Your Honor. I appreciate your time. You have a good morning.
Likewise, sir.
We all set?
Yes, sir. Yes, sir.
Okay.
Good day to you.
Yes, sir.
Your Honor, I spoke with Mr. Fortner. He did say he will be appearing for today's pretrial. I didn't, there he is right now.
Looks like he's coming in.
Yep.
This is case number 21-152234. This is Rock Orthopedic Services versus Liberty Mutual Insurance Company. The matter is set for a review hearing on today's date. Your appearance for the plaintiff, Robert Orthopedics. Mr. Fortner.
Hear me?
Yeah, something's wrong with your audio. Go ahead again, sir.
Hey, can you hear me now?
Yes.
Can you hear me now? All right, Mike
Yes, sir.
Fortner on behalf of the plaintiff, Your Honor.
Yeah, your P number for the record, sir.
Your Honor, P46541.
All right, thank you, Mr. Fortner. Good morning to you, sir. And,
Good morning, Your
counsel,
Honor.
your appearance at this time, sir.
Good morning, Your Honor. Michael Martinico, P75556 on behalf of the defendant.
Thank you, Mr. Martino, and good morning to you as well, sir.
Thank you.
Yeah,
You as
yeah.
well.
Yeah, before we get started, I want to offer my apologies or give my apologies to both you and Mike Martinico. I'm in trial over here in 30th District Court, and I got a little sidetracked dealing with that. And I'm glad Mike sent me the text message because I knew I had to do it in the back of my mind. But you know how it is when you're getting ready for trial. I got 15 things going on at the same time, so I apologize to you guys, to
No
both of
problem.
you gentlemen. Not guys, both of you gentlemen.
Thank you, sir. Thank you, sir. Mr. Martinico was quite committed to making sure. I guess one of the good things is that you guys had a conversation yesterday, and so there's been some effort to kind of move forward regarding this matter. So that's good.
Yeah, Mike's a good lawyer, a good man, and he's always been good to me, so I don't have any issues with him. Go ahead, Mike. I'll let you talk a little bit, and then
Yeah, so
I think that you're so favorable because of the same first name, but I wanted to talk.
well, we know what Michael stands for. You know, in the Bible, I think Michael was. Well, you know who Michael is, Your Honor. So you know that says a lot about our mothers.
Go right ahead, sir.
So it is pretty straightforward, Your Honor. And my understanding is a small bill, unless it's gone up. It was about 1,400 at the time of filing. Mr. Newell's case is with the MCCA. I did get some authority from them. I sent that offer to Mr. Fortner, and obviously with him being in trial, maybe he had other pressing things going on. So really, I'm just waiting to hear if that will suffice and if we can resolve, or if the bills have gone up, and go from there.
And I talked to my client yesterday, Your Honor, and Mr. Newell needs surgery. Now, I don't know if the bill's gone up, Mike, because I haven't had the opportunity to really address it. So if you would be willing to put it over 30 days, Your Honor, that might give me enough time to try to, and not, it doesn't have to be 30 days. It can be really first week of the new year. That'll give me enough time to try to get up to speed on where we're at. And we can go from there.
It sounds like maybe some accounting issues might be involved in updating the financial dynamics. So I'll go ahead and send over. I'm going to set it on the 13th of January, 9:45 a.m. And I'll set it for.
All right, Mike, will you do me a favor? Will you send me an email reminding me of that date? Because
Sure.
I'll put my calendar when I
Yep,
get
will
in
do.
today.
Yep, send it right now.
All right. All right, Yana, we'll see you at 9:45 on the 13th.
Sounds good, sir. All right.
Very
Thank
good.
you very
Thanks,
much.
guys. Take care.
good today?
Yes, sir.
Hello, good morning, ma'am. Hey, good morning, ma'am. Can you hear me? Hey, how you doing? Hello, can you hear me?
All right, do I have the parties on Felton versus Skipper in Washington? Eddie Felton? It's already.
earlier 3 months ago, a pre-trial conference was made to me. This is one of my main evidence. I don't know what type of search publications or lawyers are trying to get from that's on this. She was trying to say, who thought she paid lawyer and the judge, and there was no need for the results to be so. Also commented on the results. They had already turned in. However, her lawyers were all of my medical records denied by the judge. Only working the 8 people at the judge requested. In the court, you got to take the meeting public. Look at this thing. Also determines hot. But how does Nicki Minaj come in all this? Not that great. Now, for those of you who don't know, all cases are allowed to stand in the on social media. Question 35. All the rap artists Nicki Minaj on social media. This simple question. Any of them felt like Cardi was cool. Cardi is doing and they ask potential doers if they follow him or not. Is this for the record kind of obsessed because what? This other fan tweeted, not she trying to remove any bars from the jury. This producer who I guess is the server said they trying to make sure none of the jurors are bars because they don't want no bias. I totally agree. Yeah, come on guys. Do you seriously are bars their own, they're not like you already need at all. And they really try to I wouldn't want to bar with the jury either. But to overcome their think about it. Of a controversy. What did he have to say about it? Well, we're still talking about her say that her intentions will change. They claim that she is not going to bar of the jury because that concerns open tax. That she can't. This is a sword. This is part of me is just totally agree with you. Now, I don't know the bar that comes from me. I'm not hating on the bars because I love Nicki and her, but you guys know that I like to keep it real and say exactly how it is. I'm coming for Cardi so much of Cardi having enough legal problems and Jennifer Hunt, you know what I mean? Anyway, what's your turn? Do you think you're Cardi needs a break?
I'm gonna get her attention right now. I'm gonna tell her to call
All right,
in.
good morning.
Cardi has a chance to play the.
All right, hit *6 and that'll bring you off of mute. *6 on your device. So you're still on mute, so I can't hear you. So you gotta hit that button with the microphone so you can take yourself off of mute. Or *6 will do it.
Tap to speak.
There you go. All right, good morning to you. Good morning. Say something.
Oh, let me see.
Yeah, I got you now. I can hear you now. Good morning. Now you put it back on mute, ma'am. You have to come off of mute again.
Hello, Judge.
Yes, good morning to you.
Okay.
Good morning.
I took it off mute.
Good morning. Can you hear me?
Oh, okay.
Can you hear me? How far we turn? So ma'am, you put it back on mute. If you could take it off of mute. Take it off of mute. I can't hear you as long as you're on mute. I can hear you when you take it off of mute. There you go. All right, keep it there. Good morning. Can you hear me? Can you hear me now?
She might not be connected to the audio.
I lost it. I hear no value.
There you go. Can you hear me now? I hear you. Can you hear me? Good morning.
Sitting next to me, or you sitting on my lap?
No,
Good morning. Can you hear
because
me?
I'm on your lap.
Feel
Yes,
like
you are. Can you hear me? Good morning. Good morning. Are you able to hear me, ma'am? Say something if you can hear me.
how many people on the phone?
True. I'm sorry. It's true.
In a phone number?
All right. Can you hear me, ma'am? Good morning.
To the side.
It says, please. Okay.
Oh, she's on mute. She's on mute. Don't mess with that. Yeah.
Okay.
Okay. I was gonna know, I can hear, the judge can hear you, but can you hear him?
Okay.
She went back to you. Put that, well, you know what you should have, is you need to connect the audio. Cause you can hear. There you go. And just,
You want me to give her a number on the phone?
Maybe she can hang up and call back.
yeah,
Phone back down.
She's not even there, she stepped away.
I'm trying to get somebody to help her with.
Hello?
How you doing,
Person
ma'am?
is call
Can you hear us?
313-415. Let me see.
Can you hear me?
Hold up. I ain't get it. I ain't get the number.
Okay.
Let me see the number again. 313 965
965.
2292.
They want us to call them
I'm calling now.
on your.
Hello, hi.
Hi.
Ma'am, one of you gotta turn off because the judge is interfering.
Okay.
Turn off the video if you're on the phone. Just stay on the phone.
Okay.
Hold on.
Let me turn this off. How you turn this off, Eddie?
I turn what off?
Your phone.
You want to turn it off?
Yes, she said it was interfering.
No, she needs voice. Did you turn your voice on?
Ma'am, you still there?
Yes.
All right, good morning to you, ma'am.
It's Eddie Felton. He's blind. I'm just helping him out.
All right, thank you, ma'am.
Hello.
I have you on the video, but I don't know why you can't hear me on the video. It must not be connected to anything audio. So what I'm going to do is I'm going to allow you to do this by telephone. So we're going to hang up the video here, so that I don't have any feedback. So just one moment here, ma'am. All right, so this is case number, just 1 second here. This is case number 212-4094, strike that, 40490. This is Eddie Felton versus Amani Washington. The matter is before the court on an application to seize property based upon a judgment that was entered against the defendants, Charles Skipper and Amani Washington. That judgment was entered on the 12th of August of 2021 for the sum of $6,600. All right, what is your name for the record, please?
I'm Eddie Felton.
Thank you, Mr. Felton, and good morning to you, sir. So you have you been able to collect on this judgment through any other means, sir?
No.
All right. And so do you have, I see that you have filled out to have this executed, but have you identified someone, a officer who is going to execute this? Because you know you can't do it yourself.
Yeah, no, the officer already did it. And they got their copy, you guys, the court got their copy back, and it's for garnishment.
Yeah, I understand that. So so you're saying they already did it. What do you mean they already did it?
Yeah.
What do you mean what do you mean when you say they already did it? Because I haven't signed anything for this.
No, it came from your court clerk. Well, when I went down there, they signed and they said that everything was fine. I sent it over to Treasury. They got their copy. The defendants got their copy. Yes,
So you've already collected your judgment.
no, I didn't collect anything. No, I just submitted it to the revenue.
All right. So now let me tell you what I have in front of me. I have in front of me a request for order to seize property. That cannot be done if I don't sign this document. And my point to you is that I don't have anyone that's identified in your document as the party that will execute this. So you're saying that, what did you submit to the Wayne County Sheriff?
It was I'm not sure what the form is called, just a garnishment for either taxes or their, well, she said it's not completed because they did send it back to me and said that they couldn't see because of the, the social security number was stamped by the notary. And they needed that cleared up and they needed the address to the court.
All right, so let me point out to you that what you're talking about there is totally separate from what you have here. Okay.
Okay.
So
okay.
you're doing.
We're on the same page now.
Yeah. You're trying to collect through some other methods through the sheriff's office here. What has been submitted to me was a request and order to seize property. I'm prepared to sign that, particularly where the other side has not appeared. But you're going to have to take, we'll send this out to you. You're going to have to take this order to a sheriff or a bailiff, hire a court officer to execute this. My point to you is that, of course, you can't execute it yourself. It has to be an officer, a lawful officer to do this. You understand?
Yes, not a problem.
All right. So I'm going to sign the order in light of the judgment that you have, allowing for the seizure of property to the extent of $6,600 to satisfy the judgment. And you'll receive a copy of this. A court officer or a deputy sheriff would have to execute it. So once you get it from me, you would have to get it into one of their hands so that they can use this as a basis to execute. You understand?
Not a problem.
All right. All right. So we'll get this out to you right away. I've signed it. We'll get it out to you right away, sir. All right. Good day to you.
And it's for both or just the one?
It's as to both individuals because you have a judgment on both.
Thank you. Okay.
All right. All right. Good day to you. I wish you well.
Thank you.
You'll get a copy in the mail. You'll get the document in the mail, sir.
Thank you.
All right, thank you. Good day. Jim. Good. How are you, sir? Well, I want you to keep your focus on those things for sure. All right, that sounds good. I'll get that to you. You know, I was working with them and trying to work out something else, and so that's why we try to, like, they've got insurance. And that makes sense for us to have, because we could enforce it anyway, because we don't have an interest. What about the lack of comps? So that's the issue. Yes, absolutely. Absolutely, absolutely, yes. And except as it relates to the residential part, correct. So